Our next speaker is Harry M. Barth, Esquire. Harry is the founder and senior managing partner of BarthCalderon, LLP, and is the co-author of the book Planning Today for All Your Tomorrows. He is a nationally recognized speaker on estate, business, and asset protection planning to many incredible organizations across the country. Harry has over 40 years of experience counseling business owners and their families, corporations, and franchisees nationwide. Welcome, Harry.
Oh, thank you, Bruce. Thank you, everybody. Well, it's great to be with you. Everybody said they were sorry to see you in person. I've seen you in person for the last 5 years. This time I'm seeing you from my dining room, and I'm just as happy about that. But anyway, let's think about a few things that were said along the way. I don't mean to be political, but oh my God, who would vote for that plank of taxation? It's just out of control. And let me give you an example of that. And it kind of bears into the things that we're going to be talking about today legally. So 39.6% capital gains tax, but we forgot there's 13.3% California tax. So that means that the governments would confiscate 52% plus of our gains. Now, let me tell you something historically. I've been at this 45 years. People won't do that. People will not sell. People will hire and take into consideration gray area tax moves because we've led to the level of confiscation. People will cheat. And so as a result of people cheating, because the tax rate is too high, it's been shown historically that when they increase tax rates to those levels, the government doesn't actually collect more tax. They collect more tax when they lower taxes, and people will sell properties and people will work hard and people will do things rather than have a muted effect. So why do they do this? Well, primarily what one man's personal opinion to share is that this is a giant move to the left where it's beat up the rich, where everyone should have a house not too big, everyone should have a car not too fast. So what happens is that we are going to be seeing a significant amount of tax planning, and let's hope that many of these, we'll call it egregious tax proposals, don't come to play. Okay, enough of that. Let's move on to a bunch of things in the legal world that are very important and critical to each and every one of you. First thing, a piece of potentially good news. A few weeks ago, Governor Newsom, along with the state legislature, revised California's Homestead Exemption. Now, what is the Homestead Exemption? The Homestead Exemption is the amount of equity in our home that is safe from the claims of creditors should we be sued or forced into bankruptcy. California, for many, many years, had the following schematic. If we had a single owner of the home, $75,000 of equity was exempt from the claims of creditors. If we had two or more people owning the home, $100,000 of equity was exempt from the claims of creditors. And if we had someone over age 65 or a disabled person or a low-income person, we could manage to save $175,000 of equity. So if we had a liability, which could be COVID-related, medically related, car accident related, and the list goes on and on and on, we could easily lose our homes if we had greater than those deltas of equity. So they would give us a check for $100,000, take and sell your home, gone. Well, for reasons that I don't have time to go into, and talking about time, since I only have 20 minutes with you, here's a proposal for each and every one of you. One, we will provide, as every year in the last 5 years, my firm will provide a complimentary consultation to each and every one of you. And my firm will also provide a bank of videos that have been put together on all the subject matters, as well as white papers on the areas that I'm going to speak about today. To get that, all you have to do is text "help me" to 474747. I think that'll be on a slide at the end, but it's "help me" at 474747. Okay, so back, what happened in California? So, well, an amazing thing, almost fell out of my seat. Effective January 1st, 2021, here is the new California homestead exemption that goes into play. At a minimum, not based upon status, single, married, over age 65, the homestead exemption increases to $300,000. However, it can go as high as $600,000, which makes us the fourth best homestead exemption in America, based upon the average median price of a home sale in the county where we live. So for those of us living in Orange County, LA County, San Diego County, we're going to be at the $600,000 level. So we have a $600,000 homestead exemption effective January 1st, making many homes, if not most homes, an exempt asset from the claims of creditors. Hooray, legislator and Governor Newsom, you finally did something right in that area. In addition, to keep it viable, we're going to turn around and increase that based upon the cost of living each and every year by legislative edict. So I think that's really good. A lot of people don't know about it. For some reason or other, there's not been a lot of press about it, but everybody who attended today now knows about it, and that's really good. Next thing, if you remember when Karen was speaking, she was talking a little bit about self-directed IRA, self-directed 401ks, and the utilization of real estate and, as she called a checkbook IRA or an IRA LLC. Being a lawyer, I'm not quite as concerned. I mean, it's very important that it runs properly and gets done. But what a lot of people don't recognize is that when we have properties that are inside our IRAs, that the liability, the landlord-tenant liability, which is very, very high in California and other states, does not end at the value of the IRA. In other words, if I have a property in my IRA, self-directed IRA, and I have a landlord-tenant liability, they're going to sue me, the owner of the IRA, and my entire net worth is subject to the claims of that creditor, as well as all the other assets in the IRA. So may I strongly suggest, if we have 1, 2, or 3 properties inside our IRAs, that we have 1, 2, or 3 IRA LLCs to segregate that liability from each other and from coming through to our personal assets to the full extent of our net worth. That's a big liability that a lot of people don't recognize and can bite. So we want to make sure that everybody here has a good feeling for that, to making sure that our liabilities are limited. So I want to talk a little bit as well about COVID. Okay. So we've heard a lot about COVID today. And I want to talk about it from a little different perspective. So for many landlords, it's been challenging during the COVID pandemic to collect rent. Matter of fact, in the state of California, may even precluded from even trying to collect rent. That doesn't mean we won't ultimately collect rent. And for those of us that may be business owners, many business owners, we may have owned a restaurant, may have owned gyms, massage, and these things of that nature were shut down. They were unable to pay rent. They were unable to collect. Unfortunately, however, many leases include personal guarantees. So what's going to happen when that mandate comes off? Many of these businesses and many of our tenants are not going to be able to pay rent. And if you're a tenant, not going to be able to pay rent. And there's personal guarantees, and the personal guarantees are unrelated to the property. So we're going to have a whole scenario where there's a great possibility where landlords will be able to go after all of your personal assets in order to satisfy the rental claims. I think it's really important to engage in some appropriate and proper planning to make sure that our assets, as I've talked about every year, are appropriately and properly protected from the claims of third-party creditors wherever they may come from. And that gets down to our basic scenario where I see many landowners, apartment owners, single residential real estate owners not holding their properties properly. They'll hold them perhaps inside their living revocable trust. I want to make it very clear to each and every one of you that your living revocable trust provides absolutely no asset protection whatsoever. I think it's really important to understand we have both what we call outside and inside liability. Inside liability is landlord-tenant. So landlord-tenant liability is if our trust or ourselves are the landlords, we will be sued personally to the full extent of our net worth. That includes our house, which, well, we got a little bit of a higher homestead exemption. It'll include all of our assets. It'll include not our retirement plans, other rental properties, our businesses, the stock in our businesses, all could be lost as a result. We had a case similar to that with the mold case up in Northern California. In the mold case alone, the judgment was $3 million and close to $1 million worth of attorney's fees. And it was not inside an entity. And the people were literally forced into personal bankruptcy as a result of that, all of which was avoidable. In addition, we have liability not necessarily rising up from the property, but rising up because we got in a car crash, or we had a liability that rose up from our business, or a personal guarantee on a business lease. And now we're looking down at what we have that they can take away. If we have the properties in our own names or in our living revocable trust, we will be able to take those properties, place a lien on those properties, or prejudgment writ of execution or writ of attachment, sell those properties and gone. When those properties are encapsulated in an appropriate and proper limited liability company, we will not lose our properties. What we will get is we will get a charging order or a lien over the distributions that come out of our property with the creditor not even having the ability to force us to make a distribution. So I think it's really important, if we're going to be landowners, whether it be in self-directed IRAs or on our own, that our properties are structured in such a way as to make sure that they are the most protected for both inside and outside liability. The other thing that we've seen a lot recently is a lot of people have been established title holding trusts. These are basically living revocable trusts where we hold title to property. But and what people believe in some respects that type of trust provides some form of asset protection. I'd like to clarify that for everybody today. What it does provide when structured properly is privacy. Now, privacy is important, so people can't look up where you live, and then people who want to get you show up with pitchforks and torches, on your front lawn saying, hey, here I am, you fired me, and now I'm going to, slay your firstborn. Not very, very good. So privacy, I think, is a very important component, but I don't want people to believe that that provides asset protection. There are some ways using land trust that we can provide asset protection through the assignment of certain rights to different LLCs and the way in which they're held. Let's talk a little bit about, for a second, and I'll have all of these questions during our question and answer period. And again, remember, help me at 474747 about estate taxation. Yes, the proposal that Amanda and Matt talked about of lowering the estate tax exemption down to $3.5 million is a bit of a reality. It's all a part of the let's beat up the rich philosophy. And may I strongly suggest to each and every one of you that there is still some opportunity left this year to utilize some of the exemptions that we have before they potentially expire through the use of what we call spousal lifetime access trusts and gifts to children's trusts that can use up the large $11 million exemption amounts that we have. I think that not to do that could cost the families $4 to $8 million. And let's all please recognize, for those of us that have bought life insurance, that we own life insurance, that life insurance is included in our estate. So we have a lot of tax motivated, we have a lot of liability motivated moves that need to take place for each and every one of us. Last but not least, let me just talk a little bit and comment a little bit about what Matt and Amanda commented on Proposition 19. This was a classic bait and switch, should it be certified and put in, where they said, well, if you're over 55, you can move up, you could do a bunch of things and keep your tax basis. But what we're going to take away from you was the following things, which was not very well presented to the populace, is that there used to be, whenever any kind of property was transferred from parents to children, once upon a time, $1 million of that value was excluded, up to $1 million of value from reappraisal for tax purposes. That $1 million is now gone. So any change of property, change of ownership, whether it be parent or child or for any reason, it's a full reappraisal. The next part was where before we had an unlimited exemption amount, meaning that if my house was worth $3 million and my child inherited that house, whether they used that house as their own residence or not. They could have rented it out. They could have considered it a second home. They received my property tax basis, so there was not an increase in property taxes. Now, on the seemingly surface, that is now gone. So now, whenever we have a change of ownership, we will have, in many cases, it's quite significant, a significant increase in property taxes for the next generation. But there are a lot of questions that were unanswered. And so let me give you a few of them. So first of all, that does not happen if a child is now the owner of the house and lives in the house. So if my $4 million house, my child lives in it, what if I have 4 children? What if one lives in it? What if the 3 others do not? What happens then? I don't think we know the answer yet. Does it get reappraised? Does it get reappraised for 75%, 25%? What if we have a trust that transfers the house to the child, yet the parents remain in the house and rent it from the child? Does that make an increase in property taxes? And the list goes on and on. These are unanswered questions. These are questions that are going to have to be answered judicially by poorly written Prop 19 legislation. So we have to deal with that as well. So hopefully, Prop 15, on the other hand, which was going to increase the property taxes on commercial properties, appears to have gone down again by a small margin in defeat, while Prop 19 seems to have moved forward in a small margin of increase. So, I guess, COVID liability, okay, it's all over the place, not just that. Significant liability within our IRA LLCs. I mean, in our IRAs, not having LLCs if we're having properties. Landlord-tenant liabilities, as I've talked about for the last 5 years. Confiscatory tax environment. But we got a great new Homestead exemption. And so with that, again, remember, every one of these is an hour's conversation. Willing to speak to each and every one of you. Help me at text at 474747. And with that, I'd like to turn it back to Bruce, and I'm looking forward to joining each and every one of you on the panel. Thank you.